Hi everyone, my name is Suwansit.
Hi guys, my name is Muhammad Nafi Ushibaya.
Hi everyone, my name is Lim Ziyao.
Hi everyone, my name is Kwek Kaning.
Hi everyone, my name is He Jiajun.
Hi everyone, my name is Yu Qi-en. Today we are going to present case law and the topic is
Wage non-compliance legislation.
My name is Kwek Kaning. I will present the facts of the case for Lee Meridian Kuala Lumpur owned by Title Asia Development Malaysia Sdn Bhd versus Zulkarnain bin Hussein and others and another appeal. Now, let me identify the parties involved and the nature of their relationship. The appellant is Lee Meridian Kuala Lumpur owned by Title Asia Development Malaysia Sdn Bhd. This is the employer operating a hotel in the hospitality sector. The respondents are Zulkarnain bin Hussein and 23 other hotel workers. These are the employees working as waiters and service staff. Their relationship was a standard employer-employee relationship in the hotel industry. As shown here, this case arose from the implementation of Malaysian Minimum Wages Order 2012, which required employers to pay a minimum basic salary of 900 ringgit per month starting in 2013. The timeline shows MWO 2012 was introduced in 2012, which restructuring began in 2013, and this led to labour court claims in 2023, followed by the High Court appeal we are discussing today. Here are the key facts of how the wage restructuring was implemented to comply with MWO 2012. The hotel used part of the employees' service charge to top up their basic salaries. The purpose was to ensure the basic wage met the 900 ringgit minimum wage requirement. Looking at the table, for the first group of 8 employees on 1 October 2013, they received a restructuring letter stating the hotel would use part of their service charge for the minimum wage. All 8 employees signed acceptance. This was their written consent. For the second group of 16 employees in subsequent years, they received wage restructuring notification about basic salary top-ups. They gave consent by conduct through 3 clear actions. The first is signature at the acceptance portion of the respective letters. Second, continue working for many years and without any complaints. The employer's position was that they followed the MWO 2012 guidelines, which allowed this practice in hotels. Importantly, the service charge was variable. Employees never proved they were entitled to fixed point. Next, despite this clear consent from both groups of employees, the dispute developed when the employees filed claims for the balance of service charge, alleging that the restructuring constituted unlawful deduction. As shown in the table, the employee action was to file claims at the Labour Office. The Labour Court ruling declared the deduction unlawful and ordered the employer to repay the amount. The appeal grounds included 3 critical failures by the employees. They provided no proof of service charge entitlement. Some claims were time-barred, and they submitted incomplete payslip. A key fact that strongly supported the employer's position is that all employees worked for years without making any complaints about the wage restructuring. As a result, the employer appealed to the High Court to challenge the Labour Court decision. That concludes the facts of the case and the background leading to this appeal. I will now hand over to the next presenter.
Hi, my name is Suwansit. So now I'll be presenting the issues of this case. The first issue is whether the employer's act of restructuring wages amount to an unlawful deduction under Section 24 of the Employment Act 1955. And this issue arises because the employees allege that the hotel deducted part of their service charge to top up their basic salaries, while the employer claimed that restructuring was permitted under the MWO 2012 guidelines. The second issue is whether the employees had validly consented the restructuring of wages, which means whether the employees agree or not. And the employer argued that there are 8 employees gave written consent, which means 8 employees had signed contract, while the other 16 consented by conduct, which means these 16 employees didn't sign contract, didn't complain, and continue working. So the 8 employees who previously signed contract argued that they didn't really understand the contract. They just signed and they didn't really know that they could refuse in the first place. So the issue here is, did the employees truly agree, and does the agreement make the restructuring valid or not? And next is the third issue, whether the Labour Court erred in its interpretation of the Federal Court decision in Crystal Crown Hotel and the definition of wages under the Employment Act. So this Crystal Crown Hotel is actually another case, a previous case, and in this Crystal Crown Hotel case, service charge was considered money that belongs to employees. And in that case, the hotel followed official guidelines that say hotels are allowed to use part of service charge to help meet the minimum wages. So the issue here is, did the Labour Court wrongly apply the Crystal Crown case and wrongly treat service charge as part of wages? Because based on the previous case, it is actually legal.
Hi guys, my name is He Jiajun, and now I'll be sharing the law and the legal principles that apply in Lee Meridian Hotel case. So there are 3 laws that related to this case. So the first one will be the Employment Act 1955. So in this case, the Labour Court originally said that the hotel made unlawful deduction. which referring to Section 2 and Section 24 of the Employment Act 1955, which saying that the decision was something wrong. So we can see in Section 2, definition of wages. So the Labour Court, they actually treated service charge as part of wages. However, the High Court said this decision was wrong because service charge is not equal to wages based on the Employment Act 1955 unless there's proven otherwise. Means that if service charge were included as wages, so that the employee's wages would exceed 2,000 ringgit and the EA 1955 may not be applied. And this actually shows that the Labour Court's misinterpretation in this case. So like I mentioned just now, the Labour Court actually did unlawful deductions referring to Section 2 and Section 24 of the Employment Act 1955. So now we will go through the Section 24, which explains the prohibition of unlawful deductions. So the Labour Court actually said that the employer unlawfully deducted service charge, and the High Court disagree with these decisions because, for your information, there are 8 employees signed the letters agreeing to wage restructuring, and then the 16 others, they actually continue working for years but without any objection. So the court actually treat this as a valid concern. So the court emphasized that concern make restructuring lawful provided no fraud or misrepresentation. Since the restructuring was done with employee consent, it's not an unlawful deduction and therefore not a breach of the Employment Act. So what we can see in these terms is the Labour Court wrongly applied Section 24 in Employment Act 1955 because the service charge is not wages. It cannot be considered as wages, and because employees had voluntarily agreed to this new structuring. And then the second law that applied in this case is called Minimum Wage Order 2012, which is also known as MWO 2012. And this act is actually explained how wages of employees may be restructured. So in this act, it says that employers and employees they may negotiate to restructure wages as long as there are 4 terms right here. So the first one, the restructured wages still meet the minimum wages, and then they are not less favorable overall, and then the employees do not lose other entitlement, and last but not least, all the employees agrees either expressly or by conduct. So there are actually a guideline on NWO 2012 in terms of hotel sector, which specifically allow hotels to convert all or part of the service charge meant for employees to form part of minimum wages. So for your information, the hotel actually held town hall briefings, and then they gave written letters which explain the restructuring wages, and then all the employees, they agree by signing or through conduct. Therefore, the High Court, they actually ruled that the hotel followed the MWO 2012 correctly, and then the restructuring was actually lawful. So because of the employer complied with the guidelines and obtained employee consent, the wage restructuring was allowed under this act. Last but not least, the High Court also applied Limitation Act 1953, which is recognized as time bar on claims. So this act is actually set time limits for filing the claims. So in this case, we know that some employees, they actually claim for service charge going back many years ago, and several of these claims were actually outside of the statutory time limit, meaning that they were filed too late already. So the example here, we can see that there are claims for 2013 and 2014 filed only in 2020, meaning that the pay slips are missing for a very long period already. So we can see here, the High Court actually held the several respondents' claims should have been dismissed because they were time barred and lacked completed evidence.
My name is Mama Fushi, and I will continue for the precedents or doctrine that we refer to. The first cases that we refer to is Admin SHMRH and others versus Chan Chin Chuan and others 1995. So what is the doctrine that being applied for these cases? Unchallenged or unrefuted. Unrefuted means not proven to be false, or all the evidence must be accepted as true. So how this doctrine related to our cases? The first point is the employer testimony about employee briefing and consent was not acute in the cross-examination. Thus, it will affect the judgment of the court. The court treated it as credible and also binding. For the second cases that we refer to is Chinwell Fasteners Company SHMRH versus Sabah Kumar Pelagiary and others 2006. So what is the doctrine that are being applied for these cases? Under contract law, a person is bound by a document they sign, even if they didn't read it or understand it, unless there is a fraud or misrepresentation on it. So how this related to our cases? In our cases, 8 employees signed letters consenting to wage restructuring. The court held they are legally bound by disagreement, so making their objection invalid. The last cases that we refer to is Crystal Crown Hotel and Resort SHMRH versus Kesatuan Kebangsaan Pekerja-Pekerja Hotel, Bar and Restaurant Semenanjung Malaysia 2021. So the doctrine that being applied for these cases is first, service charge belong to the employees, and second, employer cannot use service charge to meet minimum wage requirement for their employees. How it relate to our cases? The Labour Court rely heavily on Crystal Crown cases to say that the deduction were unlawful, but the High Court said Crystal Crown involved collective bargaining, not individual consent. Therefore, Crystal Crown could not justify the Labour Court decision.
Hi, my name is Lim Yao, and I'm going to talk about the judgment and the decision of the High Court about this case. Let me begin with the final outcome of this case first. The High Court ultimately allowed the employer's appeal and overturned the Labour Court's earlier decision. This means that the hotel, Le Méridien Kuala Lumpur, no longer needs to pay the 644,884 ringgit and 10 cents that the Labour Court had previously ordered as alleged unlawful deduction from service charges. The judge also concluded that the Labour Court have made several major errors, which both in fact and in law. Because of these significant mistakes, the High Court set aside the entire award. Additionally, each employee was ordered to pay 500 ringgit in cost to the employer. Now, I'm going to explain why the High Court allowed the appeal of the employer. Firstly, the High Court found that the employees failed to prove the essential elements of their claims. Under Malaysian law, the burden of proof lies on the party making the allegation. In this case, the employees need to show three things. First, that they were entitled to 3 service charge points. Second, the exact value of these points for every month claim. And third, that deductions were actually made from their wages. However, they could not produce reliable documents to prove these points. Their employment contracts did not mention 3 service points, the benefit program document was questionable, and many payslips were missing. Because of this lack of evidence, the High Court ruled that the employee did not fulfill their burden of proof. Second, the court also emphasized that the hotel did not act unlawfully. It followed the official guidelines of the Minimum Wages Order 2012. These guidelines specifically allow hotels to convert part of the service charges into basic wages as long as it done with the negotiation and the agreement. Next, the court held that the employees had already consented to the restructuring of their wages. For 8 of the employees, consent was expressed through signed letters dated 1 October 2013. For the remaining employees, consent was implied by conduct, because they continue working for years without protesting and signed later letters acknowledging wage adjustments. The hotel had also conducted town hall briefings to explain how part of the service charges would be used to meet minimum wage requirements. Since the employee knowingly accepted the new terms and never raised objections during their employee period, the court concluded that the consent was clearly given. Furthermore, the Labour Court had relied heavily on the federal court case of Crystal Crown. However, the High Court clarified that Crystal Crown case was not applicable here. Crystal Crown case involved a hotel union and collective bargaining. The employer in that case tried to impose changes unilaterally. In contrast, the present case did not involve a union. The employees individually agreed to the restructuring and signed the relevant letters. This makes the factual situation very different. Because of this distinction, applying the Crystal Crown case in this case was legally incorrect. Another major issue was that some of the employees' claims were time-barred. Certain months they claimed for were already outside the legal limitation period. Additionally, many of the employees failed to produce complete payslips to support their alleged deductions. In some instances, they even claimed wages for months before they joined hotel. The Labour Court ignored these crucial problems and the High Court viewed this as a serious area. Hence, the High Court allowed the appeal of the employer.
My name is Yu Qi-en, and today I'm going to share about the lesson learned and the significance of the case. So through this case, we can learn the importance of evidence and burden of proof, which means that employees must prove their entitlement, such as payslip, contract reference, or credible documentation. In the Lee Meridian case, the employee failed to produce crucial evidence, which is didn't provide the proper payslip showing the exact number of the service charge point. So the court will not assume wrongdoing by the employer unless the employee can prove it through documents and facts. Because these essential documents were missing or incomplete, the court concluded that the employees did not discharge their burden of proof. The second lesson or the significance of the case is delay in complaint weakens the credibility. So in this case, employees who knew about the deduction for years but did not complain and only raised the issues in 2020. The High Court stressed that when employees are aware of change to their salary structure yet fail to voice concern, their silence amount to implied concern. Moreover, delay claims weaken the reliability of the allegations and create unfairness to the employee who has operated transparently for years. This serves as a reminder that employee must act in a good faith and cannot remain silent for extended period before bringing claims. So move to the third is MWO 2012 guidelines allowed conversion of service charge. So the case confirmed that the minimum wage order 2012 legally permit hotel to convert part of the service charge into minimum wage components. So this reflects government recognition of industry practice in hotel where service charge form a substantial part of an employee earning. Okay, next, through this case, it can become a key precedent for future service charge cases. So this judgment will likely influence assessment of future hotel industry cases. The judgment provides clear guidance for both employers and employees regarding the wage structures, transparency requirements, and consent mechanism. It also ensures consistency in legal interpretation for similar dispute in the future. So for the last lesson you can learn is service charge is not automatically wages. So the judgment clarified that service charge collected from customer is not automatically considered wages under the Employment Act 1955. The court emphasized that service charge originates from customer, not the employee, so cannot be assumed to be part of the employee fixed salary. Therefore, service charge is not considered wages. The Hotel Act of allocating a part of it toward the minimum wage did not constitute an unlawful deductions under Section 34 of the Employment Act. So, make a short conclusion is, clarify the law on service charge, concern, evidence and wages restructuring under the minimum wage order. It can also protect the employee who acts transparently and highlight the employee responsibility to prove claims and raise dispute promptly.
This is the end of our presentation today. Thank you so much. Bye-bye.